What's up, everybody? Thank you for tuning in to another episode of the CPA Zone, the podcast where we discuss tax strategies and accounting tips for entrepreneurs and real estate investors. My name is Ryan Pulis, and our company, the Pulis Group, offers tax planning and advisory services for entrepreneurs like you. Whether it's bookkeeping, tax planning, or CFO services that you're looking for, we've got you covered. What's up, everybody? Ryan Pulis here with another episode of the CPA Zone. Today, we're going to talk about yet another court case involving real estate professional status. So this one is Gossain v. Commissioner, and it's Tax Court Memo 2024-97. So this one came out on October 21st of 24. So relatively new. There's been quite a few court cases lately this past year involving real estate professional status. So I wanted to go over this one again, and we'll probably do another episode just covering real estate professional status in general in the next week or two. But in this particular case, this married couple's losses from their rental activities were disallowed. So taxpayers claimed they materially participated in the rental activity for 5 of the last 10 years because 5 prior years they passed the third test that's given to us in the Treasury regulations. So Treasury Regulations 1.469-5T give us 7 ways to show material participation in an activity. One of those is materially participating in any 5 of the prior tax years. So they claim in 5 of those past years, they materially participated by passing test 3, which is 100 hours and more than anyone else. So in this case, the taxpayers seem to have gotten the material participation qualifications confused with real estate professional status. And actually, to be a real estate professional and deduct your losses, you need to have both. So that's really what is hurting them here. So the court considered, they looked at the material participation. And from my read of this, I actually just read this not long ago myself. I kind of skimmed it and figured record a podcast episode. So I'm going to be reading a good bit away from the case itself, and anything that gets a bit too legal, I'll just kind of clarify what they're actually saying. So the court basically just assumed that they were correct on their material participation, didn't bother, and that what they also looked at was whether the husband, who was claiming real estate professional status in this case, actually qualified, and that's where they found they did not, which then made their rental losses passive. So the taxpayers here, we're looking at tax years 2018 and 2019. So as you can see, when things go to tax court, it takes quite a while for something to happen and we get a result from the courts. So this year that we're looking at, or the tax years being looked at here, 2018 and 2019, were audited together. So in 2018, the taxpayers claimed rental losses of $58,514. And at the end of this, they were allowed $11,033, and the rest was disallowed to be carried forward. So that tells us they must have had income in between $100,000 and $150,000. Because if you remember, with active participation, there's this special $25,000 allowance that allows taxpayers to deduct up to $25,000 if their modified adjusted gross income's under $100K. And then between $100 and $150, that $25,000 allowance phases out 50 cents on the dollar, and at 150,000, that allowance is 0. So they were allowed a little over 11,000. So they were somewhere in between there. 2019, very similar situation. They had rental losses of 62,000, a little over 62,000. Of that, 9,041 was allowed, with the rest being disallowed and carried forward. So again, what's happening here is the taxpayers were not able to prove that the husband qualified as a real estate professional. And remember, passive losses are only allowed to the extent that you have passive income, unless you show material participation in a regular business or with a rental property. You have to qualify as a real estate professional. Qualifying as a real estate professional gets you out of the default passive bucket. Now, you need to show material participation in your rentals to deduct those losses. So it looks like the taxpayers here had 2 rental properties, one in California, one in Hawaii. Of note here, their 2018 hours log showed 125 and a half hours for 2018. They had no log for 2019. And also during both years, 2018 and 19, Mr. Gossain, pronouncing that correctly, had a full-time job. where he worked 40 hours a week. So that's another strike against the taxpayers here, which we'll see shortly. So, excuse me, take a sip of coffee. So their rentals were considered passive because even though the courts just agreed and said, yes, you materially participated, we're not even going to bother looking at the material participation. We'll take your word for it. They did produce hours logs for prior years showing the 100 hours each year of material participation in the rentals. The courts didn't look much farther than that to prove that it was more than anyone else. And they just said, okay, 5 of the past years you had this, and out of the rule that says if you materially participate in any 5 of the last 10 tax years, you are deemed to materially participate in the current year. They just granted that. Said that's fine. However, what they really looked at was, did the husband qualify as a real estate professional? And the answer was no. That is because he couldn't clear the 2 hurdles. Remember, we have two hurdles you need to clear to qualify as a real estate professional. First is greater than 50% of your time must be spent in real property trades or businesses in which you materially participate. And the second is you must work at least 750 hours in real property trades or businesses during the year in which you materially participate. He did neither. But the courts did give them the material participation as discussed. So his hours log that they had for 2018, as mentioned, only showed 125 and a half hours. So that was not enough, obviously, to hit the 750. There's no log for 2019, so the courts assumed he had 0 hours. And having that full-time W-2 job also hurt him. There's no way. The courts don't generally assume there's no way you're going to qualify for greater than 50% of your time if you have a full-time W-2 job. So just to kind of reiterate these rules again, qualifying as a real estate professional, greater than 50% of your time, more than 750 hours in real property trades or businesses. One spouse has to pass both. In this case, they were claiming it was the husband. The courts disallowed it. So their rentals were just considered passive. So all rental activities, by definition, are passive, even if you materially participate, which in this case they did. The courts just assumed they were correct and said, yeah, sure, you materially participated. But that only you can only deduct your losses if you qualify as a real estate professional and materially participate in your rentals. So the courts did not agree that he was a real estate professional, therefore they lost. But as we mentioned in the beginning, there was some losses allowed. So $11,000 from the rentals in 2018 and a little over $9,000 in 2019. So they did qualify for a portion of that $25,000 special allowance, which again, that's when if your income is under $100,000 during the year and you actively participate. So you have to be somewhat active in the properties. And that's usually involves making management decisions. Is not as high threshold as material participation. So if you're under $100,000, you get the full $25,000 special allowance. When you're between 100 and 150, you'll get a partial allowance, which is the case for them in both tax years. So again, this is just another court case that sort of highlights the importance of making sure you are indeed qualifying as a real estate professional. You pass both tests, and it's if it's a joint return, either the husband or the spouse. One of the two has to pass both tests on their own. And then after that gets you out of the default passive bucket. Now you need to show material participation in your rentals. In this case, you can combine time for the material participation hours on a joint return. Husband and wife can combine time to hit that. But in this particular case, the real holdup was not qualifying as a real estate professional. And again, it seems like the taxpayers were confused. They were confusing material participation with real estate professional status. So I can't tell from this, but I'm assuming they probably did not have professional help. Or if they did, their professional help did not know what they were doing because they didn't even put forth the argument. They didn't have any evidence to support the real estate professional status claim. They only went in to support material participation. So that about does it for today. I hope you found value in this episode. If so, please leave us a 5-star review and hit that like and subscribe button. Until next time, have a great day. One last thing before you go. We have put out a free ebook for our listeners. You can find a link to this in our show notes. It's called the Rental Real Estate Investor Tax Guide and covers all the basic tax-related information for real estate investors. We hope you like it. Again, go to the show notes to download your free copy.
This audio segment was edited by me, Adam Rothstein. If you would like help editing your podcast or narrating your audiobooks, please email me at adamrothstein29@gmail.com. That's ADAMROTHSTEIN29@gmail.com.
So that about does it for this episode of the CPA Zone. Thanks for listening, and I hope you found something valuable that you can take away. We are taking on new clients, and if you'd like to work with us, then go to our website and fill out the client intake form on our contact page. This can be found at thepulicegroup.com/contact. That's THEPULICEGROUP.com/contact.